Today, Sally Yates testified before the House committee investigating the Russian intrusion into our democratic process. And I have to say that she conducted herself extremely well, okay? The same can't be said for various Republican senators who, instead of basically trying to get to the bottom or ascertain information regarding the Russian intrusion, they basically tried to circle the wagons around Donald Trump. Now, I'm going to play you 3 clips, one from Senator John Cornyn, one from Senator Ted Cruz, and one from Senator Al Franken. I have to say, residing in Texas at this time, that the 2 senators from Texas ended up looking like horses' asses, and especially Ted Cruz. And I'll get into the commentary on him after he completes his segment. But John Cornyn was known for grilling Miss Yates regarding her ability to push back against the president, at that time it was President Obama, if she believed that he was doing something that was either unconstitutional, basically illegal, or basically immoral. And her statement to him 2 years ago was that she would do what was right. Now, apparently, when he was questioning her, he was solely interested in her being able to push back against President Obama. But when President Trump became involved, now all of a sudden his tune changed. Here is the segment from this morning's Senate hearing.
Ms. Yates, this is the first time that you've appeared before Congress since you left the Department of Justice. And I just wanted to ask you a question about your decision to refuse to defend the President's executive order. In the letter that you sent to Congress, you point out that the executive order itself was drafted in consultation with the Office of Legal Counsel, and you point out that the Office of Legal Counsel reviewed it to determine whether, in its view, the proposed executive order was lawful on its face and properly drafted. Is it true that the Office of Legal Counsel did conclude that it was lawful on its face and properly drafted?
Yes, they did. The Office
and you overruled them?
I did. The Office of Legal...
What is your authority to overrule the Office of Legal Counsel when it comes to a legal determination?
The Office of Legal Counsel has a narrow function, and that is to look at the face of an executive order and to determine purely on its face whether there is some set of circumstances under which at least some part of the executive order may be lawful. And importantly, they do not look beyond the face of the executive order. For example, it's statements that are made contemporaneously or prior to the execution of the EO that may bear on its intent and purpose. That office does not look at those factors, and in determining the constitutionality of this executive order, that was an important analysis to engage in, and one that I did.
Well, Ms. Yates, I thought the Department of Justice had a long-standing tradition of defending a presidential action in court if there are reasonable arguments in its favor, regardless of whether those arguments might prove to be ultimately persuasive, which of course is up to the courts to decide and not you, correct?
It is correct that oftentimes, but not always, the civil division of the Department of Justice will defend an action of the president or an action of Congress if there is a reasonable argument to be made. But in this instance, all arguments have to be based on truth, because we're the Department of Justice. We're not just a law firm, we're the Department of Justice.
And in this distinguish instance, the truth from lawful?
Yes. Because in this instance, in looking at what the intent was of the executive order, which was derived in part from an analysis of facts outside the face of the order, That is part of what led to our conclusion that it was not lawful, yes.
Well, Ms. Yates, you had a distinguished career for 27 years at the Department of Justice, and I voted for your confirmation because I believe that you had a distinguished career. But I have to tell you that I find it enormously disappointing that you somehow vetoed the decision of the Office of Legal Counsel with regard to the lawfulness of the President's order and decided instead that you would countermand the executive order of the President of the United States because you happen to disagree with it as a policy matter.
No, it wasn't.
I just have to say that.
I appreciate that, Senator, and let me make one thing clear. It was not purely as a policy matter, and in fact, I remember my confirmation hearing and an exchange that I had with you and others of your colleagues where you specifically asked me in that hearing that if the President asked me to do something that was unlawful or unconstitutional, and one of your colleagues said, or even just that would reflect poorly on the Department of Justice, would I say no? And I looked at this, I made a determination that I believed that it was unlawful. I also thought that it was inconsistent with the principles of the Department of Justice, and I said no, and that's what I promised you I would do, and that's what I did.
I don't know how you can say that it was lawful and say that it was within your prerogative to refuse to defend it in a court of law and leave it for the court to decide.
Senator, I did not say it was lawful. I said it was unlawful.
Senator Durbin's next, but I have one quick.
Now, she basically shut him down because she basically framed her argument as far as right and wrong and the Constitution. He basically was saying your boss told you, did something and told you to defend it, and whether it was right or wrong, you were supposed to defend it. But that's exactly the argument that he posed to her 2 years ago. Could she push back against her boss, President Obama at that time, if he asked her to defend something that was wrong? So her answer was absolutely correct. And you notice that he didn't really try to go back against her after she made her statement. Now, the next one I want to show you is Ted Cruz. Now, I'm going to play you Ted Cruz, who's supposed to be the lawyer's lawyer. I'm going to play you his entire exchange between Clapper and Yates. And I want you to pay particular attention to his interchange with Yates, because Ted Cruz has got a history of quoting portions of the law, but not the entirety of the law and everything that goes to the law. And Ms. Yates basically straightened him out and put him in his place to the point that he did whimper away like a sick puppy. Here we go.
Mr. Clapper, you testified as to the harms that come from leaks, the harms that can come to our national security, and you also testified about the importance of protecting classified information and keeping it classified. During your many years in intelligence and at the DNI, have you ever knowingly forwarded classified information to a non-government employee on a non-government computer who did not have authorization to receive that information? Mr. Clapper, you testified as to the harms that come from leaks, the harms that can come to our national security, and you also testified about the importance of protecting classified information and keeping it classified. During your many years in intelligence and at the DNI, have you ever knowingly forwarded classified information to a non-government employee on a non-government computer who did not have authorization to receive that information?
All right. Now, I played that twice purposely because Ted Cruz is trying to point back to Hillary Clinton. And that's specifically what that particular question was all about. So I just wanted to give you a frame of reference as to what that question was about.
Not to my recollection, no, sir.
And Director Clapper, what would you do at the DNI if you discovered that an employee of yours had forwarded hundreds or even thousands of emails to a non-government individual, their spouse, on a non-government computer?
Well, I'm not an investigatory or prosecutorial element, but if I were aware of it, I would certainly make known to the appropriate officials that was going on.
Would that strike you as anything ordinary?
Hopefully not.
What concerns would that raise for you?
Well, it raises all kinds of potential security concerns. Again, depending on the content of the email, what the intent was, there's a whole bunch of variables here that would have to be considered. But potentially, again, this is a hypothetical scenario. It could be quite concerning.
What would you expect to happen if you made a referral of an individual who had forwarded hundreds or even thousands of classified information to a non-government employee on a computer?
Whatever the potential transgression was, if there were sufficient evidence of a compromise, we would file a crimes report. That's a standard procedure that we use when there's the potential for investigating and prosecuting someone.
Last week I asked similar questions to FBI Director Comey, and he said an individual who did that would be subject to, quote, significant administrative discipline, but that he was highly confident they wouldn't be prosecuted. Do you share that assessment?
Well, I don't know. I don't know. I think the track record is that the prior administration, I think, prosecuted more people for leaking than anyone in any other administration in the past. So it's difficult to do that, and there are many cases we could not prosecute or even seek a crimes report because the potential audience of people that could have been the perpetrator of these insecurities could not be identified.
It is true that other individuals who were not in the direct employ of the Democratic nominee for president were prosecuted for that conduct. Let me shift to a different topic. Director Clapper, you also testified that you're not aware of any intercepted communications of any presidential candidates or campaigns other than the Trump campaign that's been discussed here. Is that correct?
Yes, but that's to my knowledge. But prior administrations, prior campaigns, that wouldn't have been visible to me. So I can't say.
But in 2016, you're not aware of any other campaigns or candidates?
No.
And Ms. Yates, same question to you.
I'm not aware of any interceptions of the Trump campaign.
And are you aware of any intercepted communications of any other candidates or campaigns?
No.
Okay, because earlier when Chairman Graham had asked you that, I thought you declined to answer, so perhaps I misunderstood that.
And I may have misunderstood the question. I thought the question I declined to answer was a different one than that. So I'm glad I got a chance to clear it up.
Okay, so you have no information of any interceptions of the Bernie Sanders campaign, Hillary Clinton campaign, or any other candidate in 2016 or campaigns?
No.
Okay. Let's revisit the topic, Ms. Yates, that you and Senator Cornyn were talking about.
Okay.
Is it correct that the Constitution vests the executive authority in the President?
Yes.
And if an Attorney General disagrees with a policy decision of the President, a policy decision that is lawful, does the Attorney General have the authority to direct the Department of Justice to defy the President's order?
I don't know whether the Attorney General has the authority to do that or not, but I don't think it would be a good idea. And that's not what I did in this case.
Well, are you familiar with 8 U.S.C. Section 1182?
Not off the top of my head, no.
Well, it is the binding statutory authority for the executive order that you refused to implement and that led to your termination. So it certainly is a relevant and not a terribly obscure statute. By the express text of the statute, it says, quote, whenever the President finds that the entry of any alien or of any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation and for such period as he shall deem necessary suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem appropriate. Would you agree that that is broad statutory authorization?
I would, and I am familiar with that, and I'm also familiar with an additional provision of the INA that says, no person shall receive preference or be discriminated against in issuance of a visa because of race, nationality, or place of birth. That, I believe, was promulgated after the statute that you just quoted, and that's been part of the discussion with the courts with respect to the INA, is whether this more specific statute trumps the first one that you just described. But my concern was not an INA concern here, it rather was a constitutional concern, whether or not this the executive order here violated the Constitution, specifically with the Establishment Clause and equal protection and due process.
There is no doubt the arguments you laid out are arguments that we can expect litigants to bring, partisan litigants who disagree with the policy decision of the president. I would note on January 27th, 2017, the Department of Justice issued an official legal decision, a determination by the Office of Legal Counsel, that the executive order, and I'll quote from the opinion, the proposed order is approved with respect to form and legality. That's a determination from OLC on January 27th that it was legal. 3 days later, you determined, using your own words, that although OLC had opined on legality, it had not addressed whether it was, quote, wise or just.
And I also, in that same directive, Senator, said that I was not convinced it was lawful. I also made the point that the Office of OLC looks purely at the face of the document and, again, makes a determination as to whether there is some set of circumstances under which some portion of that EO would be enforceable, would be lawful. They importantly do not look outside the face of the document. And in this particular instance, particularly where we were talking about a fundamental issue of religious freedom, not the interpretation of some arcane statute, but religious freedom, it was appropriate for us to look at the intent behind the president's actions, and the intent is laid out in his statement.
Final, very brief question. In the over 200 years of the Department of Justice history, are you aware of any instance in which the Department of Justice has formally approved the legality of a policy and 3 days later the Attorney General has directed the department not to follow that policy and to defy that policy?
I'm not, but I'm also not aware of a situation where the Office of Legal Counsel was advised not to tell the Attorney General about it until after it was over.
Thank you, Ms. Yates.
Sally Yates 3, Ted Cruz 0. Like I said, Ted Cruz has got a history of quoting particular laws, but not quoting them in their full context or subsequent laws that have a material effect on the laws that he quotes. So this guy likes to cherry pick, but Sally Yates, being a better lawyer than Ted Cruz, was ready for his ass. And as you notice, he had nothing further to say. Now, the third one is going to be Al Franken. And I always like to put Al Franken up because out of all the members of the Senate that are on various committees, he is normally the only one who is not an attorney. So hang on one second. Okay, here's Al Franken's portion of the testimony.
Thank you, Mr. Chairman. I want to thank General Clapper and Attorney General Yates for appearing today. We have the intelligence communities have concluded, all 17 of them, that Russia interfered with this election, and we all know how that's right.
Senator, as I pointed out in my statement, Senator Franken, there were only 3 agencies that directly involved in this assessment plus my office.
But all 17 signed on to that.
Well, we didn't go through that process. This was a special situation because of the time limits and what I knew to be who could really contribute to this and the sensitivity of the information. We decided it was a conscious judgment to restrict it to those 3. I'm not aware of anyone who dissented or disagreed when it came out.
Okay, and I think anyone who's looked at even the unclassified report is pretty convinced that this is what happened. And one of the questions is, why do they favor Donald Trump? There are a number of contacts and communications that between Trump campaign officials, Senator Leahy mentioned, Carter Page, a former campaign advisor, Paul Manafort, who was a former campaign manager and chief strategist, Rex Tillerson, Secretary of State, got a friend of Russia award, Roger Stone, and of course Jared Kushner, White House senior advisor, son-in-law, and Michael Flynn. All this, that's a lot in my mind. Now, going to Flynn, he appeared during the campaign on Russia Today. Russia Today is the propaganda arm, one of the propaganda arm of, and now you, Gerald, since you've retired, have you appeared on Russia Today?
Not wittingly, no.
No. Okay. And General Flynn received $37,000 for sitting next to Putin at the 10th anniversary of Russia Today. It seems, all this seemed very odd to me and raised a lot of questions. I was struck that Mr. McGahn did not ask you in the second meeting why DOJ, General Yates, would have concerns that the National Security Advisor had lied to the Vice President. In the first meeting, did you mention that he might be compromised?
Certainly, we went through all of our concerns in the first meeting, and it was in the second meeting that he just raised the question of essentially, why is this an issue for the Department of Justice if one White House official lies to another?
Okay, I don't understand why he didn't understand that.
I'm not sure I can help you with that, Senator.
This is, General Flynn after that, for 18 days, stayed there and was in one classified thing after another. There are policies to deal with who gets clearance, security clearance, and not. Executive Order 12968 outlines the rules for security clearances. And it says that when there's a credible allegation that raises concern about someone's fitness to access classified information, that person's clearance should be suspended pending investigation. Is that right? The executive order also states that clearance holders must always demonstrate, quote, trustworthiness, honesty, reliability, discretion, and sound judgment, as well as freedom from allegiances and potential for coercion. Is that right? And yet, the White House counsel did not understand why the Department of Justice was concerned?
Well, to be fair to Mr. McGahn, I think the issue that he raised, he wasn't clear on was why we cared that Michael Flynn had lied to the Vice President and others. Why that was a matter essentially
I think that's clear.
within DOJ jurisdiction.
I think it's so clear.
Yeah.
I can't. And the president had told President Obama had told the incoming president-elect that 2 days after the election, don't hire this guy.
I don't know anything about that.
Well, that's what we've heard. And we have McGahn doesn't understand what's wrong with this, and then we have Spicer, the press secretary, saying the president was told about this. The president was told about this in late January, according to the press secretary. So now he's got a guy who has been, the former president said, don't hire this guy. He's clearly compromised. He's lied to the vice president, and he keeps him on. And he lets him be in all these classified phone, he lets him talk with Putin President of the United States and the National Security Advisor sit in the Oval Office and discuss this with Putin. Is it possible that the reason that he didn't fire him then was that, well, if I fire him for talking to the Russians about sanctions, and if I fire, what about all the other people on my team who coordinated? I mean, isn't it possible that the reason, because you ask yourself, why wouldn't you fire a guy who did this? And all I can think of is that he would say, well, we've got all these other people in the administration who've had contacts. We have all these other people in the administration who coordinated, who were talking. Maybe that. I'm just trying to we're trying to put a puzzle together here, everybody. And maybe, just maybe, he didn't get rid of a guy who lied to the vice president, who got paid by the Russians, who went on Russia Today, because there are other people in his administration who met secretly with the Russians and didn't reveal it till later, until they were caught. That may be why it took him 18 days until it came public to get rid of Mike Flynn, who was a danger to this republic. Care to comment?
I don't think I'm going to touch that, Senator.
Senator Blumenthal.
All right, so basically the bottom line is this, folks. Mike Flynn was a prick when he was working within the Obama administration, to the point that President Obama fired him. President Obama did clear him or vet him for the position that he was in. The thing about this particular situation is that when Flynn was moving into a much higher position, Director of National Intelligence, that required a secondary vetting, which Donald Trump did not do, okay? Now, if that secondary vetting had been performed, they would have come up with all of the Russian contacts, et cetera, et cetera, et cetera. But even that being said, when President Obama told Trump not to hire this guy, and I'm pretty sure he laid out at least some of the reasons why Flynn shouldn't be hired, that should have drawn up a red flag. Okay, Trump's loyal to his guys. But when Sally Yates came in here and specifically was talking to the White House attorney and laid everything out for him to the point that he had asked to see what she was talking about, and she had agreed to show it to him, but then she was fired pretty much, this was during the second meeting, she was fired the next day. Okay, that's still more red flags. So at the point where she said this guy should have been walled off from everything until Donald Trump re-vetted this guy, or he not even re-vetted, but vetted this guy on his own for the higher clearance, which would, number one, have protected the country from Mike Flynn and his collusion with the Russians. And number two, it would have shown, unfortunately, that Donald Trump's judgment and the way that he was going about handling things and people was highly suspect. But again, this put a lot of glory, this particular Senate hearing put a lot of glory on Sally Yates, and it showed that the Republicans, at least some of them, not Graham, because Graham's going after the Russians, but some of them, their sole interest is going after the former administration, trying to attack Sally Yates, which they were totally unsuccessful in, and attempting to protect Donald Trump. And they absolutely failed in this endeavor.